And when something is framed as this is how you become complete, refusal stops being neutral. Saying no to FGM is no longer just a preference, it became defiance. Ladies and gentlemen, boys and girls, welcome back to another episode of Katiba na Chai, a show where we talk about the Constitution because clearly we cannot be trusted to freestyle freedom without an attack, Today, let's start with something I think we all agree on. Adults should be allowed to make their own choices. The sentence feels so obvious, it almost doesn't deserve discussion. If you're an adult, you can get a tattoo, you can jump off a cliff with a parachute, hopefully, you can get cosmetic surgery, you can even fast for religion, You can even refuse medical treatment and say, Daktari, I hear you, but my ancestors. And the law generally responds with maturity. Hey, that's your life? Go ahead. So, the rule seems simple. If an adult understands the risks and consent, the state should mind its own business. Clean, neat rules. Very liberal, very constitutional coded. But let me ask you something, quietly. Are there any choices the state is allowed to stop? Can you sell your kidney if the rent is due? Can you consent to permanent injury? Can you agree to harm if saying no means losing your family, your community, your entire social existence? Because once consent is absolute, it stops being selective. And that's where things get a bit uncomfortable. So before we even talk about today's court case, I'll give you a bit of a background. We need to talk about what FGM actually is and why it exists. Because FGM did not start in Kenya. It didn't start in Africa. It didn't definitely start in a church or a mosque. It predates Christianity, it predates Islam, it predates colonialism, which immediately ruins several of your WhatsApp arguments. I'm sorry. This was never per se a religious requirement. It was a social system. FGM was tied to ideas of purity, marriageability, family, honor, and control of female sexuality. And in many communities, it wasn't framed as violence. It was framed as preparation, preparation for womanhood, preparation for marriage, preparation for acceptance. And when something is framed as this is how you become complete, refusal stops being neutral. Saying no to FGM is no longer just a preference, it became defiance. So in parts of Kenya, girls who were not cut, they were mocked, excluded, or quietly removed from the marriage market. And historically, marriage was not about romance, no. It was about survival. So by the time we say an adult woman has consented, we are already ignoring years of training that made that consent feel expected. And that's what walked into a Kenyan courtroom in 2019. Not shouting, not protesting, but politely. Now let's get about who brought this case. Because this was not just a random petition. Dr. Tatu Kamau, an academic, a public intellectual, who has extensively written on culture, autonomy, and African identity. So she was not speaking from a place of ignorance. She was speaking from a place of principle. The argument was this. Not that FGM is good. No. It was sharper than that. Her argument was, if we claim to respect African women as thinking adults, we cannot just turn around and then tell them their choices only count when we approve of them. And she took aim at specific parts of the law. She challenged Section 5 of the Prohibition of the Female Genital Mutilation Act, which criminalizes the act of FGM itself. She challenged Section 19, which criminalizes aiding, abetting, counseling, or even procuring FGM. She challenged Section 20, which criminalizes the use of your premises to carry out FGM. And then she challenged Section 21, which criminalizes possession of tools used for FGM. The argument was that these sections violated the Constitution. Article 28, the right to your dignity. Article 32, freedom of conscience, religion, belief, and opinion. Article 44, the right to participate in cultural life. And Article 43, the right to health, including controls over one's body. In short, if the Constitution means anything, it must mean my body, my rules. And here's the uncomfortable truth. Her argument kind of made sense. If consent protects sex, tattoos, cosmetic surgery, and refusing chemotherapy, then banning adult FGM sounds inconsistent. I mean, at least on paper, which is exactly the problem. Because the law is where ideas go to be stress tested by reality. Or as courts like to put it, yes, your argument is elegant, but would you like to meet society? This case was never really about FGM. FGM was a test case. The real question was this: can the law stop adults from choosing harm, especially when that harm comes with applause? So once Dr. Kamau made her case, the courtroom didn't fall silent. In fact, it filled up. The Attorney General stood up and relied on Article 24 of the Constitution. The limitation clause. The Office of the Attorney General argued that rights are not absolute and may be limited where the limitation is reasonable and justifiable in an open and democratic society. Also told the court that FGM causes irreversible physical and psychological harm, and that the limitation imposed by the Act was proportionate to the objective of protecting women and girls. The DPP also joined in. The DPP's concern was enforcement. The DPP argued that for allowing adult FGM would fatally undermine the enforcement of the ban on child FGM. Because once a practice is legal in one context, it becomes easier to disguise it in another. And in law enforcement terms, that is not nuance. It's a loophole. Then the anti-FGM board came and they told the court. They spoke from experience. They described medicalized FGM. Girls were even presented as having consented. Families reframing coercion as culture. And they wanted the court that what looks like when choice in theory often looks like fear in practice. Other organizations came in, like Equality Now and other women's rights organizations, joined as interested parties. They argued that legalizing FGM would increase social pressure on women to conform. As one submission put it, consent in such settings is illusionary rather than real. At this point, the courtroom was full, not noisy, heavy. And this is where the judges posed the room. Not dramatically, not angrily, just silence. And then the court reframed the entire case. The judges said, and this is a direct quote, consent obtained in an environment of social pressure and cultural expectation cannot be said to be free. They went further and they stated, the Constitution must be interpreted in a manner that protects the vulnerable from practices that are harmful, even when such practices are defended as cultural. And then that line quietly decided the case, because the court held FGM is by its very nature a harmful practice, and no level of consent can sanitize its effect. That was it. The judges were clear on this was not an attack on culture. They acknowledged Article 44, but they added that cultural rights do not extend to practices that violate human dignity and bodily integrity. So they upheld Section 5 of the Act, they upheld Section 19, Section 20, and Section 21, all of them that were being challenged. Because as the court put it, the state is entitled to take preventive measures to eliminate practices that have the effect of perpetuating discrimination and harm. At some point, the court had to choose between a beautiful argument and an ugly reality. And courts historically do not trust beauty when reality keeps sending receipts. So, what does all this mean? Kenya's anti-FGM law is not just progressive. It's deliberate. It recognizes that some traditions survive, not because people love them, but because leaving them is expensive. And this case doesn't end with FGM. Because once the law admits that history can corrupt consent, a lot of other things will start sweating. Faith healing, organ trade, cultural rights sold as identity. Generally, choices that sound free until you zoom out. This judgment does not answer all those questions, but it changes how we ask them. Because freedom is not just the ability to say yes. Sometimes it's the law asking whether you are allowed to ever say no. And in this case, the court looked at this question and quietly said, enough. If you enjoyed this breakdown, subscribe to Katiba na Chai. We do law, power, and society without shouting and without dumbing it down. Like the video and share it with someone who says, it's my choice, a bit too fast. And I'll see you on the next episode.